The notary looked at my father across the conference table and said, "Mr. Whitfield, I need you to explain why this signature doesn't match any ID your daughter has ever issued." My father said, "She signed it. She was there." The notary turned the deed toward him and pointed to the date. I had been in Phoenix on that date. I had receipts, boarding passes, and a hotel folio that said so. I had not been in Knoxville. I had not been in any room with that deed, and my signature, my name, my handwriting, was on a document transferring a house I co-owned to a buyer I had never met, for $214,000 I had never received. My father looked at the deed for a long time, then he looked at me. I didn't say anything. I had learned, a long time ago, that silence is more powerful than anything you can say, out loud, when the evidence is already on the table. He rubbed his forehead. He had been rubbing his forehead my entire life. Whenever he was caught in something he couldn't talk his way out of. I recognized the gesture, the way you recognize a song you haven't heard in years. You know every note before it plays. That was the moment I want to tell you about. But to understand why it mattered, why it hit the way it did, you need to understand the house, and what it meant, and how we got there. My name is Carla Whitfield. I'm 48 years old, and I grew up in a brick ranch house on Sycamore Lane in Knoxville, Tennessee. 3 bedrooms, a covered porch, a backyard that backed up to a creek. My mother planted roses along the side fence every spring for 22 years. She died 9 years ago. Ovarian cancer, which she handled the way she handled everything, teaching. Quietly and without complaint until it was too late to do much about it. She left behind my father, a house that was paid off, and a will that had been drawn up by a local attorney named Howard Cleese, who I later learned charged $300 for a basic estate document and did not always ask the right questions, either. The will divided the house equally between my father and me. Not the contents, not the furniture. The actual property, 50% to Raymond Whitfield, 50% to Carla Whitfield. My mother's instructions. I know why she did it. She didn't say it out loud, but I understood. She knew my father. She knew how money moved through his hands. She loved him, and she did not fully trust him. And the house was the only thing of real value she had to leave. And she split it because she wanted me to have something she could be certain of. I was 39 when she died. I was already 9 years into my career as a forensic accountant. I had handled estate documents before. I read my mother's will carefully. I understood what it said, what I did not do, and this is the part I have to live with, was record my ownership interest with the county at the time. I knew it was best practice. I told myself I'd do it after the estate closed. I trusted the process. I trusted my father, more than I should have. I didn't record the deed. That gap, that small, careless gap, was the thing my father stepped into 7 years later. My father and I were never close in the way some fathers and daughters are. He was not unkind to me, he was just directed elsewhere. He had a son, my brother Donnie, who was 4 years older than me, and who had been my father's version of himself since the day Donnie could throw a baseball. My father coached his teams. He drove him to every tournament. He co-signed Donnie's first car loan, his first apartment, his first business. I was the one who stayed close to my mother, the one who went to college on academic merit and paid the rest in loans. The one who came home on holidays and sat in the kitchen and kept quiet while my father held court about sports and politics and everything Donnie was doing. I loved my father. I want to be clear about that. I also knew exactly where I ranked in his mind. It was not a painful thing anymore by the time I was an adult. It was just a fact, like the weather. You don't rage at the weather. You dress appropriately and you move on. When my mother died, I flew home from Columbus. I was living in Ohio then, and I helped arrange the funeral and sat with my father for 2 weeks, while neighbors brought casseroles, and my brother came and went, and my father watched television and cried quietly at night when he thought I was asleep. It was during those 2 weeks that I handled the estate documents. I read the will. I noted the house co-ownership. I met follow through. And then I went back to Columbus. And life continued. And 7 years passed. The first signal came in the form of a tax notice. I still get mail at my parents' address sometimes. Old accounts, subscriptions I've never fully updated. My father forwards things occasionally. Most of the time I ask him to just throw them away. But this particular piece of mail he forwarded without comment. It was a Knoxville County property tax notice for 47 Sycamore Lane for the current tax year. The notice was addressed to Raymond Whitfield and Carla Whitfield, joint owners. That was normal. That was how it had been since my mother's will was executed. Except the notice showed a new assessed value, ED. The house had been assessed at $198,000 2 years ago when I had last checked. The new assessment was $241,000. That was reasonable for the market. Knoxville had appreciated steadily over the past decade. What was not reasonable was a line near the bottom of the notice, marked transfer date. It said, 14 months ago. If you have ever been the person in your family who reads every line of a document when everyone else just reads the total, you already understand what I felt when I saw that. A transfer date means the property changed hands. A transfer date 14 months ago meant the property had been conveyed to someone, and the tax notice was still addressed to Raymond and Carla Whitfield. That made no sense. If the property had been sold, the tax records should reflect new ownership. The only reason the old names would still appear on a new notice with a transfer date was if the transfer had been recorded but the county's update cycle had lagged, or if the transfer had been recorded incompletely, or if something had gone wrong in the middle. I did not call my father. I went to the Knox County Register of Deeds website and searched the property address. There were 2 recorded documents. The first was the original deed from when my parents purchased the house in 1987. The second was a warranty deed recorded 14 months ago. Transferring full ownership from Raymond Whitfield and Carla Whitfield to a buyer named Douglas Fenwick for a stated consideration of $214,000, signed by both grantors, including me. I had not signed that deed. I had not sold that house. I had not received $214,000 or any portion of it. I had never heard of Douglas Fenwick. I called my father. He let it ring 4 times, which he never does. He always picks up on the second. When he answered, he said, "Hey, kiddo," in a voice that was just slightly too casual. I said, "Dad, I need you to tell me about the deed on Sycamore Lane." Pause then. "I've been meaning to talk to you about that." Here is what he told me. In that first phone call, he said he had needed money. He said his retirement account had taken hits in the market and his fixed income wasn't covering his bills. He said the house was sitting there, and he couldn't maintain it, and he hadn't been able to reach me, which was not true. I call him every Sunday, and he had spoken to an attorney, and they had helped him handle it. I asked him what attorney. He said his name was Gary Pryor. A local guy. I asked him what Gary Pryor had said about my co-ownership interest. He was quiet. I said, "Dad, my name was on that deed. You needed my signature to sell. Did Gary Pryor explain that to you?" He said it could be handled. I said, "How was it handled?" Another pause, then, "I don't know exactly how the paperwork worked. He took care of it." I want to tell you that I stayed calm in that moment. I did. But it was the kind of calm that has a floor to it, that goes down only so far before it hits something solid and unyielding. I could hear my own voice getting very steady, which is what happens when I am most serious. I said, "Dad, someone signed my name to a warranty deed. That is a forged signature on a legal document. That is a felony." Understand what I'm saying to you, he said. "I needed the money, Carla. Not, I didn't know. Not, that can't be right. Just, I needed the money." I hung up and sat at my desk for about 15 minutes. Then I called my attorney. Her name is Renata Kim, and she handles real estate fraud and estate litigation out of Nashville. I had referred clients to her before. When I explained what I had found, she said, send me everything, the county deed record, the tax notice, that's original will, and find out who Gary Pryor is. Gary Pryor turned out to be a real attorney, licensed, active, no disciplinary record between the. His practice was primarily real estate closings and basic estate work. I'd looked at his website. He was the kind of solo practitioner who handled whatever came through the door. I called his office. His assistant said Mr. Pryor was unavailable. I left my name and number and said it was regarding 47 Sycamore Lane and a forged deed. She took the message with the careful neutrality of someone who had been trained not to react to anything. He did not call back. Renata sent him a formal letter within the week. Meanwhile, I started building the full picture. I pulled the closing documents from Knox County, everything associated with the sale. Renata had a contact at a title company who could access the HUD settlement statement from the transaction. The sale had closed for $214,000. After realtor commissions and closing costs, the net proceeds were approximately $196,000. Those proceeds had been disbursed to one account. My father's account, not split, not half, not $98,000 with a second transfer to a second beneficiary. $196,000 to Raymond Whitfield, deposited in full. My share, approximately $98,000, had never been separated out. Never held in escrow. Never sent anywhere, Before I tell you what I found when I looked at where that money went, let me say this. I did not want to believe my father had made a deliberate choice to do this. I wanted, very badly, for there to be a version of this that was a misunderstanding. An attorney who hadn't explained it properly, a process that moved too fast. For an elderly man to track. I wanted that version. The bank records did not give it to me. The $196,000 had arrived in my father's checking account 14 months ago. Within 6 weeks, it had moved $40,000 to Donnie, not labeled as a gift. Not labeled as anything. A transfer, a regular bank transfer, from my father's personal checking to an account in the name of Donald Raymond Whitfield. $22,000 to a joint account my father shared with a woman named Brenda Costas, who I later learned he had been in a relationship with for 3 years, without mentioning to me, $18, Z-room, to pay off a credit card, in my father's name, $15,000, to another account I couldn't immediately identify. The remaining $101,000 was still sitting in his checking account, drawn down slowly over 14 months through regular expenses. He had received $196,000 from the sale of a house I co-owned, and he had used $80,000 of it, within 6 weeks, on my brother and his girlfriend, and his own credit card. Before I even knew the house had been sold, my brother had received $40,000 from the proceeds of our mother's house. And he had said nothing. I pulled up my phone and scrolled back through our text history. Donnie and I talked maybe once a month, brief, surface-level exchanges. He had texted me 11 months ago. Thinking about you. Hope work is good. He'd replied. You too. Things are busy but good. He knew. He had to have known. A $40,000 transfer doesn't arrive in your account without a conversation. That was when I stopped trying to find the innocent version of the story. My father called me 3 days after our first conversation. He said he wanted to explain. He said he was sorry for how things had happened. He said he had been stressed and overwhelmed, and Gary Pryor had told him it could be handled and he had trusted him. I asked, "Did you know my signature was forged?" Silence. "Dad," he said, Pryor said it was a legal way to handle a co-ownership when one party is unavailable. I said, "I wasn't unavailable. You have my number," he said. "I thought you'd make it complicated." There it was. He thought I'd make it complicated. Which meant he had thought about calling me. He had decided not to. He had gone to an attorney, explained the situation, and chosen a path that did not include me. Because I might ask questions. Because I might want my share. Because I might make it complicated. I had been erased from the transaction, not because he forgot I existed, but because I might not cooperate. My mother had split that house to protect me, and my father had found a way around it by making me disappear on paper. I said, I need you to understand that what was done is not legal. My signature on that deed is forged, that's fraud. And I'm going to pursue this through every channel available to me. He said, Carla, I'm 71 years old. I said, I know how old you are, Dad. He said, please don't do this. I said, you started this, I'm finishing it. I hung up. I did not call him back for 3 weeks. My brother called me 2 days later. He said he had heard I was making things difficult. I asked him if he had received $40,000 from the sale of Mom's house. He was quiet for a moment, and then he said it was a loan. I said, is there a loan document? He said, it was between me and Dad. I said, Donnie, do you understand that the house was half mine? That money was half mine. That means 12,000 of what he gave you came from my proceeds. He said, I didn't know about the deed thing. I said, you received $40. He's 00, and you didn't wonder where it came from? He didn't answer. I said, I'll need that in writing. He said, Carla, come on. I said, I'll have my attorney send you a letter. He hung up. Renata filed a quiet title action in Knox County, a legal process for resolving disputes over property ownership. The action named my father, Gary Pryor, and the buyer, Douglas Fenwick, who had purchased the house in good faith and was now the innocent party caught in the middle of a fraud he had no part in creating. I felt genuinely bad about Douglas Fenwick. He had bought a house, paid $214, 00 for it, and was now in the middle of a legal dispute over whether the sale was valid. Renata said he would likely be made whole through title insurance. His title insurance had covered him against exactly this kind of defect. He was not going to lose his home, but the fraud still had to be documented. Gary Pryor responded to Renata's letter with a 5-page letter of his own written, in the careful language of someone who knows he has done something he can't fully defend. He argued that under Tennessee law, a co-owner who has not recorded their interest can be subject to certain conveyance processes. He argued he had advised my father of the risks. What he did not explain was the signature. My name, on the deed, in handwriting, that was not mine. A notary stamp from a Knoxville notary, whose commission I verified, who later, when Renata contacted her, said she had notarized the document based on an ID presented to her, and that she had not independently verified whether the person presenting the ID was who they claimed to be. She had notarized a forged signature. She was required, under Tennessee law, to verify identity. She had done a cursory check and moved on. Renata built a case around 3 things: the forged signature, the absence of any legitimate conveyance mechanism for my interest without my consent, and the $98, 0 in proceeds that had never been disbursed to me. The mediation was scheduled for a Monday morning in February, at a conference room in a Knoxville law firm, Neutral Ground. My father arrived with Gary Pryor, and a second attorney Pryor had retained. I arrived with Renata. My brother was not there. He had sent a written statement saying he had no knowledge of the deed or the signature. I noted that he had not mentioned the $40,000. My father looked older than I had seen him in years. He sat across from me and didn't quite meet my eyes for the first hour. The mediator was a retired judge named Norma Bassett, who I liked immediately. She was 70 years old, gray-haired, and did not waste words. She laid the deed on the table. She pointed to my signature. She said, Mr. Whitfield, I need you to explain why this signature doesn't match any ID your daughter has ever issued. And my father said, she signed it, she was there. And I put my boarding passes on the table. My hotel confirmation from Phoenix. The receipt from the hotel restaurant the night of the date on the deed. And my father looked at those documents, and then he rubbed his forehead. I had seen that gesture my whole life. It was the only honest thing he did in that room. The settlement took 4 months to finalize. Gary Pryor's malpractice insurance settled for $94,000, close to my full equity share, with a portion held back in legal costs. Pryor's also agreed to cooperate with a state bar ethics investigation. His license was later placed on a 2-year probationary status. Even my father was required to repay $20,000 from the proceeds he had transferred to Donnie, documented as a clawback of misappropriated co-owner funds. That obligation fell to my father, not my brother, Giba. Donnie was not named in the settlement because I could not prove he had known about the forgery. I believe he knew something was wrong. I cannot prove what he knew. The Douglas Fenwick's title insurance covered the title defect. He kept the house. The title was cleared. I received a total of $94,000. It is not nothing. My mother paid off that house over 22 years. Yipeen. She planted roses along the fence, and she sat on the covered porch on summer evenings, and she planned carefully for what would happen after she was gone. Either. She put my name on that deed because she wanted me to have something real. I have the money now. I do not have the house. I will never walk through that backyard again, or see the fence where the roses used to grow. That is the part of this that no settlement covers. My fathers and I speak occasionally now, not often. The conversations are careful and short, the way conversations are when both people know the shape of what happened and are choosing, for various reasons, not to say it out loud again. He is 71 and he lives alone, and I am still, in some fundamental way, his daughter. Those facts coexist. I have made peace with the fact that they coexist. The woman named Brenda, his girlfriend, called me once, about a month after the settlement. She said she wanted me to know she hadn't known anything about the house. I said I believed her. I think I did. Donnie and I have not spoken since February. I don't know if that is permanent. Some distance settles into permanent before you notice it has. What I think about sometimes is my mother at that attorney's office, 20-some years ago. Sitting across from Howard Cleese and saying she wanted the house split. I wonder if she imagined this outcome. I wonder if she thought her plan would hold. She gave me a 50% interest in a piece of property, and she trusted the record to protect me. She was right about the record, just not about who would try to erase it. I found a cashier's check stub in my father's files during the settlement discovery. It was made out to Gary Pryor, dated 3 months before the closing. An advance payment, $5,500, for services rendered. My father had planned this, not in a panic, not in an emergency. He had walked into an attorney's office 3 months before the closing, paid a retainer, and set it in motion deliberately. I kept the stub. It sits in a small, clear envelope in my files. I don't keep it because I'm angry. I keep it because it is the truest document in the whole story. It is the ones that shows the intention, not the mistake, not the confusion, not the overwhelmed man who trusted someone he shouldn't have. The one that shows he knew exactly what he was doing and did it anyway. If you believe the truth always shows up somewhere in the records, subscribe before the next account is opened. My mother signed her name to a will to make sure I had something. My father signed my name to a deed to make sure I didn't. The records knew the difference. They always do.